endorsements, acceptance, and tender, how to use the system against itself. What if you could turn the system's own rules into your remedy? In this video, you'll discover how endorsement, acceptance, and tender, often misunderstood legal actions, can be weaponized lawfully to challenge debt, enforce claims, and assert your position as a creditor using UCC and IRS instruments. At the heart of modern financial law lies a set of mechanisms so rarely discussed that even practicing attorneys fail to grasp their power: endorsement, acceptance, and tender. These three concepts, codified in UCC Article 3, form the legal architecture of commercial paper, and they can be strategically deployed to assert control over any alleged debt or instrument presumed against you. An endorsement is not merely a signature. When one endorses a negotiable instrument without recourse, it conveys the instrument with no further liability, functioning as a personal indemnity clause. This is codified in UCC Section 3-415b. It means that if the instrument is dishonored or goes unpaid, the signer bears no further responsibility. This form of endorsement is your legal firewall. Acceptance, under UCC Section 3-409, is defined as the drawee's signed engagement to honor the instrument as presented. In legal practice, delivery equals acceptance. If a bank or institution physically receives your endorsed instrument, particularly when mailed via certified or registered mail, the law presumes acceptance. The instrument is legally taken, and the obligation shifts. Tender, as defined in UCC Section 3-603a, is the act of offering full payment or performance. When a party tenders payment or an instrument in satisfaction of a debt, and the opposing party refuses to accept it, the obligation is considered discharged. No further action may be enforced unless fraud, coercion, or mistake is proven. Together, these three elements form a triad of enforcement that can be turned back on any bank or creditor. Here is the procedure. 1. Endorse the instrument without recourse, naming a specific payee, e.g. the bank. 2. Deliver the instrument via certified mail to establish lawful acceptance. 3. Document the tender and refusal, if applicable, and assert discharge under UCC Section 3-603. 4. If refused, initiate litigation citing breach of commercial law and unlawful dishonor. When used properly, this method flips the burden entirely. You are no longer the debtor, you are the secured party creditor who lawfully tendered a valid instrument. The refusal to accept and process it becomes a cause of action. Footnote: this section outlines how without recourse endorsements, lawful delivery, and UCC tender statutes can discharge alleged debts and expose creditor fraud.